SJC-10269, Commonwealth versus Peters.
Thank you.
Good morning, Mr. Wilson.
Good morning, members of the court. My name is Barry Wilson. I appear on behalf of Mr. Peters. This involves an incident that occurred on June 3rd of 2006. The lower court, Judge Nickerson, allowed the motion to suppress. The appeals court reversed. As a matter of fact, the appeals court, in its decision, said something I think that in actuality is what they did. They said, quoting Commonwealth versus Young, but whether an exigency existed and whether the response of the police was reasonable and therefore lawful are matters to be evaluated in relation to the scene as it could appear to the officers at the time, not as it may seem to a scholar after the event with the benefit of leisured retrospective analysis. I suggest to the court that's exactly what the appeals court did. They said that the findings of fact made by the trial court were appropriate. Well, the trial court found that on June 3rd, 2006, there was a phone call. The facts are somewhat, I suggest, somewhat ambiguous, but whether a gunshot was fired or not fired prior to the phone call is not clear. We're not sure when the shot was fired because the neighbor said they heard a loud noise. When the officer arrived, he went into the house where Mr. Batella was with his mother, and his mother was somewhat hysterical. And he saw a hole in a window, and he lined it up and determined. The judge did find there was a basis for probable cause. And what I would suggest to the court is, certainly we agree with the ultimate determination the court made, but I do not, as we argued, as I argued before the motion judge, I don't believe there was a basis to.
Well, there was a broken window too, wasn't there?
There was a broken window in the other house.
Right.
But we don't know when that occurred either. And what we do know is.
So they had a bullet hole, and then they had a broken window, and they said 2 + 2 = 4.
The judge found probable cause, but he said that it was stretching. I mean, he implied that. But let us just fine. I don't agree with that, but we can accept it.
Okay.
We can accept that. But let us not forget, though, that at the same time, they knew that a young woman and her mother had been packing and had left. They knew that another gentleman had left. And supposedly the only person who gives them anything other was a Mr. DeSimone, who doesn't testify, but fills out an affidavit that says he heard somebody arguing, but he just never even looked up. Never said anything about a woman being in danger. That was Rogers. That's not supported in the record by the testimony of Detective Murphy or Bowman. And it's not supported by the affidavit of by the police report involving Mr. DeSimone.
But when you say Rogers' testimony isn't supported, he's the neighbor?
No, Rogers is the police officer, and DeSimone, Mr. DeSimone was the neighbor who was tending to his garden.
Right.
And at page 64 in the appellate, he said, he was tending to a plant in my yard. He hears an argument, a house next door. I heard someone come out, get in a car, slam the door behind him, and then back out of the driveway. I never even looked up. And Rogers says that he said he was fearful for a woman. How do we go from that, from what DeSimone wrote, what he told Detectives Murphy and Bowman, to what Rogers? As the trial judge found, I would suggest to you that Rogers went in, and so then he called up and asked for permission to look for victims. But before he goes in and looks for victims, he dons Kevlar helmets and with Curtis with a shotgun, and he with a pistol.
Isn't that consistent with legitimate concern that there might be an armed person in the house?
Yes.
And there might have just been a shooting in the house? I mean, doesn't
Well,
that reinforce the position that the officers reasonably believed there was an emergency that required them to go into the house that way?
Yes, and as a matter of fact, even though I don't agree they have the right to go in, I'd like the court to focus on that, because that's just it. They were in fear, and they're looking for either victims or suspects.
Right.
Well, you're a victim or suspect, you're looking for a body. So they go through, and this isn't a McMansion. This is a small
We all
little
watch
house.
crime shows. You clear the house first to make sure there are no perps there, and then perhaps you take a more careful look to see if there are any victims. I don't know.
No, I don't agree with that, and that's not what the trial judge found, because number one, this was an emergency exception. They asked to go in because they were looking. He said, I want to look for victims. Then they turn it around and say they're suspects. Let us remember, he had knocked on the door once, just when he walked up initially, and nobody answered. He walked around this small little house, didn't see anything. He had information that a man had driven away. He had information that a woman and an older woman had been packing and had driven away. There was no indication that anybody was there, but even assuming that there was, when they went in there looking for other suspects and or victims, it's the same idea. And I would suggest to you, it's a lot harder to hide someone who's dead than it is someone who's alive. So when they're looking all over for a body in a small space. But not only do they go upstairs, they go downstairs, but then they go to the kitchen, and they got to go down to the basement, and they've got 2 dogs down there. They get one dog. They can't get the other dog. So they have to call the animal control officer. So they proceed to sit in the kitchen for 15 minutes while they wait for the animal control officer.
Why isn't that perfectly reasonable?
Well, we're going. The judge found that was okay. They go down to the basement. They find nothing. Now, they have searched. They've been in the house. They have no reports of domestic violence. They have no other reports of anything. They see no blood. They see nothing. They don't mention it's disturbed in any way. Nothing. And all of a sudden, Roger says, Urt whistle. Maybe we got to go back. We got the Urt whistle exception. I suggest to you that what the officer envisioned was a headline in a paper. We missed it again. We missed it. That's not in the law. As the trial judge said, at best, Roger's explanation as to the purpose of this search was his subjective belief or an after-the-fact rationalization or something done out of human curiosity and the desire to be thorough.
So your position is the police only get to look once?
My position is this was an emergency exigent circumstances. And if they went in there looking for a victim, they did. They did it. They went and they looked. They didn't find anything. How many times you get a bite at the apple? Because the search wasn't thorough enough, it was supposed to be, quote unquote, a sweep. And to even support that, it's quite curious that in the affidavit filed by Detective Clarkson, he neglects to mention they went in and did it twice. Seems to me Clarkson even knew that they'd exceeded what they were supposed to do.
But are you saying that for the police they get one chance to do a sweep, or are you saying that the police may arguably get a second chance, but only if there is a reasonable basis after the first sweep to believe that they may have missed something?
Well, to be candid with you, I would argue they get one bite at the apple, but I can agree to the second one because there's nothing that changed here. The only thing that changed here was we got the Urt whistle exception. There was nothing that they saw that occurred. As the trial judge said, time had lapsed. The danger had passed. There was no concrete evidence of a struggle, of a missing person, or of a documented history of domestic violence. The trial judge, who had the ability to evaluate the testimony and listen. I mean, in the prior arguments, we have to understand what police do. Well, I may have a different opinion about certain things, but the trial judge was in the best position, and I think he gave them the benefit of the doubt. Personally, I don't know if this would have risen to even going in the first time. However, after they went in the first time, after they'd been confronted with all these facts, what changed? They were inside a house for 15 minutes, a house that had maybe 2 or 3 rooms on the first floor and a couple rooms on the second floor. They had 2, 3 officers. Then they had a dog officer. They were there. They didn't see anything.
They didn't leave the house, did they?
No.
So this is all, it's all one event. They didn't leave and come back
No.
after they thought of the Entwistle case.
No. But that's all. But it's even more important. What had happened while they'd been there that all of a sudden, except for Entwistle, that said they should go do it again. That's the only thing. I mean, I can't create that that officer says, "Oh yeah, Entwistle, we better go and be thorough."
More thorough.
More thorough.
So, but you portray this as a second search. Isn't it really just one search?
No. The idea was this was not supposed to, this was, whether it's a search, a sweep, but they're looking, supposedly, they got permission to go in for a victim. Then it changes suspect, victim. Well, it's a body. It's a small space. We're not talking about they're looking for even an infant. They're looking for adults. I mean, where are you going to hide? And you're in the house for 15 minutes. You don't see any blood. You don't see even any indication of there being a fight. Nothing. You have information that the parties have left. And then you say, Uncles, I hate to go back to it, but that's what the police officer said. And the trial judge, on some levels, was benevolent, in my opinion, in his findings as to Rogers. Because Rogers, I suggest, you know, Mr. DeSimone, his testimony about DeSimone, that wasn't supported. And he has to give you the testimony about DeSimone because in his time of quote-unquote danger, let us not forget that in the short amount of time that he's investigating, he walks up to this small house and he knocks on the door and he doesn't have a helmet on, it's Kevlar, nor does his gun drawn. So all of a sudden, he wasn't in such fear at that juncture, but somehow he has this conversation with Mr. DeSimone, which is not supported by the statement, nor supported by other officers. And now, all of a sudden, they're in fear.
If they had gotten a warrant,
Excuse me?
if they had gotten a warrant, could they have gone through the house twice the way they did here?
If they'd gotten a warrant,
Yeah.
I don't understand how they would have got the warrant.
No, if they, just assume that they had gotten a warrant, could they have gone through the house twice?
If you have a warrant,
Yes.
twice. Last time I saw a piece with a warrant, they go in and they trash the house. Of course, I mean, I
So
don't
the
mean
answer is
to be
yes.
facetious.
They could have gone through twice.
They have a warrant. They spend hours in a house when they have a warrant. I mean, with all due respect, I don't see the relevancy to it. They didn't have a warrant. When police have a warrant, they go in and they tear the house apart. I don't know if they go through once, twice, whatever. They just drag it and tear it apart.
We've tried to put some limits on that, but let me go back, just change the facts a little bit. They had done they were doing the first sweep of the house. Their commander shows up on the site. What's going on? We've swept the upstairs. We're now looking at the downstairs. Commander says, "Have you looked under the beds?" Oh, darn, we didn't do that. Can they go back and look up under the beds?
Well, see, the idea, why are we changing the facts?
No, I'm just wondering what because essentially that's what's happened. They've done the sweep and they go, oh, we didn't
Did
look
you-
in certain
Is
places
it
we probably
really-
should have.
Is it really consistent that police officers are in danger and they're looking for suspects and/or victims? They're not looking under beds. They're looking wherever a body could be. If I'm to accept that police officers are trained in certain manners and they are worried about their physical being, wouldn't you look wherever you think a body could be? I think that's a fair inference that we have to draw. So in regards to your question, I would have assumed they looked under the bed, and nobody indicated they didn't. They looked wherever a body could be. And they didn't find anything. And they didn't find anything to support any of their conclusions. I would suggest that the court may agree with the trial court as to the first entrance. But after they'd been in the house, they found nothing to support that anything had gone on in conjunction with the information they'd be presented, that the parties had left. Mind you, that the neighbor couldn't even identify Mr. Peters at the hearing as the person who left. We don't even know if he was there that day. We don't know who was there that day. And mind you, the first phone call said that perhaps had been fired in the yard, and Rogers had called for a metal detector.
Mr. Wilson, the
Yes.
flashing light.
I'm done.
You're done.
Thank you.
Thank you, Mr. Wilson. Ms. Holler?
Good morning, Your Honors. May it please the Court, Julia Haller on behalf of the Commonwealth. With me is Assistant District Attorney Robert Moriarty. He's transferring into our appeals department and beginning his journey with us. Let me just address a couple of factual points. The defense makes a point about DeSimone, who is kind of the linchpin of the exigency here. The judge resolved the finding of fact, a factual credibility question, in favor of Rogers and tends to find Rogers to be a very credible witness in his findings of fact. The judge in his findings of fact says that Rogers talks to DeSimone. DeSimone says, and this is after Rogers has been at the Botello's and has seen the bullets and seen the shots and he arrives on scene within a couple of minutes because he's actually patrolling in that area. He happens to be in that area. And he goes and speaks to DeSimone, and DeSimone says, well, I heard arguing. I heard somebody leave very quickly, like they wanted to get out of there, and I'm afraid for the woman who lives in the house. And there's evidence that the police had knowledge that there were 3 or 4 people, including one woman who lived in that house. And it's at that point that Rogers...
What was the evidence that there were 3 or 4 people who lived in the house?
I believe one of I can't remember exactly where it is, but there was testimony that 3 men and 1 woman, it might even been from DeSimone, lived in that home. Rogers testifies that they've received evidence that at least 4 people lived in that home.
Did he say from where he got that evidence?
I believe he does. I don't have it on the top of my head, but it is in the transcript.
I'll tell you why, because what is the evidence that a woman and her mother were packed up and left?
That evidence comes in... Is that Pago? Okay. Sorry, it's Mr. Pago. Thank you. Mr. Pago he testifies that there's 4 people too, doesn't he think? No? Okay, I'm sorry. I'm sorry. We're relying on you for my evidentiary thing. I apologize. But yeah, Mr. Pago says that he sees 2 people leaving earlier, but that's earlier. And we don't know is it reasonable to assume that if they left earlier they didn't come back, given DeSimone's statement that I heard them arguing and I'm concerned for the woman who lives in the house. So we don't know the time differential between those 2 incidents.
When did Mr. DeSimone fill out the report?
That is very unclear and was subject to much examination and cross-examination. Rogers gets a statement from him. There's some evidence that the statement maybe has the time when Rogers speaks with him, but there's some question as to when he was asked to fill out the police report. I believe it's Curtis testifies that, or Rogers says we'll fill out a report, but the report comes later. And it's not, Rogers does not have this witness statement, and it doesn't come into the police custody until after the search has been made.
Well, Renato Botello,
Yes.
who lived in the house that the bullet entered.
Right.
He heard a noise, went downstairs, saw a broken window. He looked outside and he saw the defendants driving away in a car.
He saw a man driving away in the car, yes.
And it was after that that DeSimone told Rogers.
Right, it's within minutes of that,
Yeah,
yes.
DeSimone told Rogers, Officer Rogers, that he had heard arguing and then saw somebody drive away quickly in a car, and he was concerned about
Right.
the occupant of the house.
Right, this is all within a matter of minutes of that time, and this is a rapidly unfolding situation. You have a gunshot through a neighbor's window that literally just misses an occupant of this house by 1 to 2 feet, and she is understandably hysterical. Rogers is there within moments because he's in the neighborhood literally doing a patrol. He then goes over, meets up with DeSimone, hears this evidence, goes around the house, finds the broken window with the flower pot, and at that point decides that he needs to make an inquiry into the home to find out, is there somebody in there? And they are concerned for their safety. At this point, the other officer, Curtis, has arrived. Within moments, a third officer comes in, the natural resources officer. They've donned their extra equipment necessary to protect themselves if there is still a gunman within the home. I mean, you can't assume that we know now that there's no other gunman within the home, but as this is unfolding with Rogers, within 5 or 10 minutes of the gunshot, you can't look back, and this is the whole hindsight aspect. This is what the police officers are faced with. They get and make the entry, and the judge even makes the finding of fact that they were on tunnel vision. They were looking for someone who was going to endanger them. They wanted to clear the space, make sure that there wasn't a gunman still within the home at that time.
Is it reasonable to infer, as Mr. Wilson suggests, that they looked in every place? I mean, they have tunnel vision now, so they're not looking for drugs that are lying on top of bedspreads. They're looking for bodies. Is it reasonable to assume that they looked wherever a body could be?
I don't believe it, on the first sweep you can reasonably assume that, because as the judge says, they had tunnel vision, and as
Precisely because the tunnel vision
was for the safety. No, the tunnel vision was, and Officer Rogers testifies clearly, the tunnel vision was to find a suspect with a gun, to make sure
So they're looking for a human being.
they're looking for a human being with a
body.
gun. No,
They're looking
well,
for a body.
they're looking for someone with a weapon who could be a
That's a
threat
body.
to them.
That is a body.
Well, a body, but not a victim at
Yeah,
that point.
A body with a gun.
A live body.
Yeah,
They're not looking for a victim at that point. They're looking for someone
looking
who
for a
poses
live-
a threat to them.
They're looking for a live body who is on clear notice that somebody is about to come into the house.
Right,
So they're looking for a live body that might be hiding somewhere.
right. And that's why they take so long with the basement, because they want to clear the whole space. They have the two vicious dogs.
Is it reasonable to assume that when they went into the bedroom, they would look under the bed? Where would you hide in a bedroom?
I don't know that we can assume that from the facts, because,
So, no, I didn't say assume, just as a reasonable inference.
but if they're saying you look under the bed, they're looking for a person with a weapon.
Yes, so you look under the bed. You bend down. You
But
look
they're
under the
not
bed.
looking for evidence. They're
No,
not
they're
looking
not
for,
looking for
right,
evidence.
but and it's clear that the judge makes a finding of fact that they're looking for suspects. They're not looking for bodies. They're not looking for victims. They're not looking for evidence at this point. They're looking to clear the scene for their own personal safety.
Well, they have a reason to go in the house.
Right.
And the reason to go in the house is because they are fearful that something is happening in the house
Right.
that involves people.
Right.
It's either somebody with a gun or there's somebody hurt.
I don't think that it's mutually exclusive. I
No,
think
that-
it
it's
could
not
be
mutually
both.
exclusive, but what I'm saying is that's the reason to go in the house.
Right. And it's the evolving. It's one large
Right.
episode. It's
So they
we
go
clear
in,
the scene.
And that's why Officer Rogers is so insistent that Mr. DeSimone told him that he was fearful for the woman who lived there.
As the judge resolved it, that DeSimone
So
did
he
tell
was worried
Rogers.
about at least two things that we can say.
Right.
One is that there's a woman who may be,
Potential victim, yes.
and the second is, because he's put all of his gear on, that there may be somebody there with a weapon that
We
may shoot at somebody
Right.
coming in.
We have a gunshot fired within minutes of them making the entry into the home. So,
If One of the reasons they were there is, they were there under the emergency exception to the warrant requirement.
Right.
And one of the reasons, one of the justifications was to look for an injured person.
Community caretaking at its most basic.
Well, the emergency exception to the warrant requirement.
Right.
What are the constitutional limitations on the scope of a search under the emergency requirement, under the emergency exception?
And the emergency exception
compared to if they had a search warrant.
With the emergency exception, it's clearly limited to what was reasonable to the officers at that time, with what they were faced with at that time.
Does the scope of the search, are there constitutional limits that only permit one search of a house?
I don't believe
one run through.
one
the
run
house?
through. No, the only thing I could kind of compare this to when I was thinking of it, and I don't want to get myself in trouble, is this is not like a first complaint or a fresh complaint problem. This is, you don't get one shot like you do with that aspect of an evidence.
You would agree, though, wouldn't you, in response to Justice Wiener, would you? If they had done what they did and they left, I think maybe Justice Cordy asked this, they get back to the station, the commander says, did you look under the beds? They say, oh my God, we didn't. Do you think it would be within the scope of this same emergency exception? They could go back to that house and then look under the
Well,
beds?
I think that's probably closer to the Lewin case and the cases which hold that now you have the chance, go get the warrant, you've left. Here, where everything basically unfolds within the 30 minutes, and there are cases that, I mean, there's no set rule, but there are cases that say that 30 minutes seems to be a not unreasonable time to execute your safety and your search for victims in your emergency exception. But I think, once they leave, it does become more attenuated. Of course, it would all be based factual, is each episode certainly is a case by case. I don't think in this area, because these cases are extremely fact bound, that you can really come up with just more than what Your Honors have already come up with in fashioning or applying these factual cases to the standards that we already have developed.
Let me ask you this. If assume we agree with you in this case, and we say, okay, the Commonwealth's right, does that mean that the rule going forward would be that the police could break their searches into two parts and say, the first thing we're going to do in every case when there's an exigency is we'll search for live bodies, we'll finish that, and then we'll go back and do a more thorough search to see if there are dead bodies?
No, not at all. What happened here, and as the analysis certainly is this was an evolving, ongoing one search
Say it's
situation.
one search.
Situation. It was not
But
done.
the reference to the Whistle case, doesn't that tell us that that became the second search?
Well, it's all within the scope of a very short period of time, and then they say, oh, we finished looking for live bodies. Now let's look for dead bodies, or look for
Is there
victims.
any reason why they couldn't have gone to get a search warrant for that?
Again, as Rogers testified, he said, we didn't know if there was somebody bleeding out while we're waiting for this time to pass.
He's been sitting in the kitchen for 15 minutes.
Well, it's also they're in the kitchen. They're waiting with
But he's
the
been
dogs. They've
sitting
got
in the
barking dogs.
He's
They're
been
not just sitting there.
in the kitchen.
But they're
So-
waiting to finish the safety search at that point.
There's nothing in the record that I could see that said it was unsafe for them to leave the dog where the dog was
Well,
and
Rogers
to go back.
Rogers testifies that he wanted to complete the safety search, and that meant waiting until the dogs could be secured, because the dogs were loose in the basement and they didn't know who or what may have been in the basement. He testifies that they complete the search of the house and then they go to the basement, and it's all part, again, of this tunnel vision. They're going to clear that basement, make sure there's nobody in the basement with a gun, and they have to get the dogs.
Maybe what tunnel vision is police knowing what the implied limits are when they break into a house without a warrant.
But the judge testifies, he finds as a fact that the tunnel vision in this case was the search for suspects. He doesn't find as a fact that it was a pretextual search.
No, it's not pretextual. I'm saying that they were doing the right thing. Let's just go to what's been referred to as the
Sorry,
end
I'm in a
whistle.
duck and cover mode. I apologize.
No, the end whistle exception. We know that in that case, at least the allegation is
Right.
that the bodies were covered. So now what they do is they go and take off all the covers on, I don't know how many beds they were. They open a chest that could have a body in it. Can we do all of this without a search warrant?
That's beyond what happened here.
No, I'm just asking you.
I think when you've got a scene of again, it's if you've got a scene of a homicide, there is a little more leeway to search for things. But
There's no allegation here. There's no allegation of a history of a missing person. There's no allegation of domestic violence. There is an allegation. There is a report of a shooting. No question about that.
right.
And there is a report of there may be a woman in there. A concern for a woman in there.
Right. And as this is, again, it's a rapidly evolving situation. You have a very recent gunshot. You have a concern by a neighbor, I'm concerned. And then you don't have any, and as the judge finds, there's no, the police aren't looking for evidence. This is not any attempt to try and garner evidence. They are looking for bodies the second time around. And as the officer looks under the bed, then he sees the gun, and then he looks up and he sees the drugs in plain view. There is none of the use, as say in some of the other cases, say in the Supreme Court cases of Lewin or Mincy, or of Lewin and Thompson, where it is used as a pretext and not to go where you have hourly searches that take hours and you have more thorough. This was not a thorough general search. It was based upon the circumstances that the officer had. This was a reasonable, measured response, looking for suspects number one, and then once you'd cleared suspects, looking for victims. And then they do stop once they have see the drugs. They freeze the scene. The other two officers actually continue, clear the upstairs, make sure there's no bodies upstairs, and then they apply for the warrant. So they don't actually seize and begin searching. They do what they believe is the right thing and go and get a warrant and then search the house. And my time is up. There are no further questions. I will submit in my brief.
Thank you, Ms.
Thank you.
Holler. Can we take a short break?